The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson. Good luck with today's lesson.
In this section, we're going to focus on securities regulation. So both the federal and state levels regulate securities, but when the states regulate securities, it is known as blue sky laws. The state laws may vary, but will generally focus on anti-fraud provisions as well as broker-dealer licensing and registration provisions. Under the National Securities Markets Improvement Act of 1996, Congress recognized the dual system of the state and federal governmental regulation of securities was duplicated. Under the Act, Title I exempted state review and registration securities offered by mutual funds and stocks listed on the New York Stock Exchange, the American Stock Exchange, the NASDAQ National Market System, and other stock exchanges the SEC identified. The Act does allow states to investigate and enforce actions involving fraudulent, deceitful, or unlawful conduct, eliminates duplicate registration, and allows states to collect filing fees. Now, following the 1929 stock market crash, Congress enacted in a 7-year project of securities reform and passed 6 statutes regulating initial offerings as well as the secondary market. 2 of the main statutes are the Securities Act of 1933 and the Securities Exchange Act of 1934. The 1933 Act regulates initial sales of securities, while the 1934 Act deals with the regulations of the secondary market. The other acts you should be familiar with are the Securities Enforcement Remedies and Penny Stock Reform Act of 1990, which is the Remedies Act, the Securities Acts Amendments of 1990, the Market Reform Act of 1990, and the Private Securities Litigation Reform Act of 1990, also called PSLRA. Now, the Remedies Act allows the SEC to enforce remedies and start administrative proceedings against individuals or entities. And the Securities Act Amendments of 1990 allows for sanctions for those SEC-regulated individuals who violated foreign laws. 2 additional acts you should note are the Sarbanes-Oxley Act of 2002, known as SOX, and the Dodd-Frank Wall Street Reform and Consumer Protections Act of 2010. Let's talk about securities and what are securities. Securities are investments in a common enterprise with profits to come from the efforts of others. Securities can include stocks, bonds, or even investments contracts involving things like cattle, orange groves, or oil and gas wells. The 1933 Act applies to the sale of stocks, security bonds, limited partnerships, and so forth. Unless specifically exempted, securities must be registered. So what is a registration statement? It's a document disclosing specific financial information regarding the security, the issuer, and the underwriter. A seller must also provide a potential purchaser with a prospectus which sets forth the key information contained in the registration statement. So when does the registration process begin? You will see that the Act has broken it into 3 sections: the pre-filing period, the waiting period, and post-effective period. Now, generally the process begins with the filing of a registration statement, which we identified as being a document containing detailed information about the offering, the company, and its managers. Upon filing, the potential offerer can run tombstone ads and distribute red herring or a preliminary prospectus, but they cannot sell shares. So here, if you kind of look at figure 45-1 on page 932, you'll see the registration periods detailing out these 3 things: the pre-filing, the waiting, and the post-effective. Now, exemptions from registration include intrastate offerings as well as small offerings and securities sold under the Regulation D exemptions, including rules 504, 505, and 506 exemptions. The omission or misstatement of material information in a registration statement results in liability for officers, directors, and experts. Let's talk about the Securities Exchange Act of 1934. This act regulates the secondary market, and it requires companies not exempted to file quarterly and annual reports. These reports are the 10K reports and the 10Q reports. Under SOX, the company's CEO and CFO must give written certification of these reports. Part of the 1934 Act are Section 10B and Regulation 10B-5. These prohibit insider trading, a material misstatement or omissions of fact in security sales transactions, or prohibits insider trading. So what then is insider trading? Insider information. Insider information is going to be privileged information on company business that's only known to employees. So who may be insiders? Insiders may be directors or corporate employees. Temporary insiders may be people retained by the corporation for professional services. For example, the attorney, the accountant. And tippies may be individuals who receive information from insiders or temporary insiders. The Private Securities Litigation Reform Act of 1995 placed restrictions on lawsuits, standards from recovery, and the management of class action lawsuits. Under this act, a safe harbor exists. Finally, the 1934 Act controls short swing profits and regulates the process for tender offers. Because accountants play a role in financial reporting, both the 1933 Act and the 1934 Act have sections that deal with the accountant's liability. The SEC promulgated Rule 2E, which deals with discipline of accountants, attorneys, consultants practicing before the agency. Now, the National Association of Security Dealers, NASD, which is a self-regulatory organization, merged with the New York Stock Exchange and formed one self-regulatory organization known as the Financial Industry Regulatory Authority. Again, you can review some of this all on Figure 45-1. We're going to continue this lecture and go on into Chapter 47, the management of the corporation. So who owns a corporation? Shareholders or stockholders will own the corporation, and shareholders have only an indirect say in the management of the corporation in that they elect directors. But they also have the right to vote on various corporate matters, including amendments to the articles of incorporation or mergers or consolidations. Shareholders usually vote for directors at the annual meetings, and they may have special meetings for other matters. All meetings will require notice, and all states have quorum requirements for shareholder representation at the meetings. The notice requirement of shareholders' meetings can be waived either expressly by signing a written waiver of notice either before or after the meeting, or impliedly by attending the meeting and not objecting to the lack of notice. The quorum will represent the number of shares that must be present either actually or by proxy for votes to be taken. Okay, so the quorums. The quorum is going to be calculated at the beginning of the meeting, but if the quorum withdraws after that, courts are split as to whether votes taken thereafter will still be valid. Generally, it doesn't break the quorum. So let's look at the following example. The Big Bang Theory Company's bylaws specify that its annual meeting is to take place every year on April 1st. Leonard is a Big Bang Theory Company shareholder of many years standing. This year, he gets notice of the company's annual meeting. The notice shows the date, time, and location of the meeting, but it neglects to mention anything that will be discussed. Is there any problem here? No. Shareholders are entitled to notice of the shareholder meetings. For annual meetings, the notice need not mention what's to be discussed unless the matters in question are unusual or extraordinary. And as a result, Leonard's notice is proper. Now, directors who are elected by the shareholders will manage the corporation. Directors' qualifications can be specified by the Articles of Incorporation or bylaws. But in the absence of such restrictions, anyone who has capacity to contract can be a director. So let's talk about the directors for a moment. When we talk about the directors, they're given great discretion in the management of the company. In the absence of fraud or illegality, courts will not intervene in the corporate governance process. Directors actually own two principal duties to the corporation. Okay? So what are those principal duties? They're the duty of care and the duty of loyalty. Now, directors must use great caution to be certain that they do not have any conflicts of interest, where their loyalty is going to be divided between their own interests and those of the corporation. Directors are liable for the failure to exercise prudent business judgment, and this prudent business judgment rule is known as the business judgment rule, which holds that directors' judgments can't be challenged unless they are tainted by fraud, a conflict of interest, or illegality. Thus, when we're talking about this, the business judgment rule protects our directors from any liability. Okay, if the directors made an honest mistake and it was mere good faith, error, and judgment. Now, what is the director's duty of care? Because we said that's one of the duties that they owed. The duty of care requires that directors exercise the degree of skill, diligence, and care that a reasonable, prudent person would exercise in similar circumstances. Simply put, the duty of care typically means that directors can't be negligent. The directors must act on an informed basis, in good faith, and with the honest belief that the action was in the best interest of the company. Directors must exercise caution in takeovers because of the potential for self-interest. Corporations are now entitled to pass amendments that permit corporations to indemnify directors for duty of care violations. And these indemnification provisions apply assuming there is no bad faith, breach of loyalty, or improper personal gain. Directors will delegate the day-to-day responsibilities to officers, agents, and employees of the corporation. Directors will elect the officers, and the Revised Model Business Code Act allows for as many officers as the board desires and with any title. Officers also have a fiduciary duty to the company and cannot make gains at the corporation's expense as when they take a corporate opportunity. So here, officers implement the policy decisions of the board of directors. Officers and employees have authority to bind the corporation to third parties under the same rules of authority covered in agency. Thus, officers may bind the corporation because they have the pre-existing authority to do so, or even though the officers lack the authority to bind the corporation to the transaction in question, the corporation had ratified the transaction. Criminal liability can be imposed on officers and employees for conduct that's carried on for the corporation. Examples of potential criminal liability statutes include licensing, environmental statutes, and acts of bribery prohibited under the Foreign Corrupt Practices Act. In some cases, federal statutes impose criminal liability on corporate officers supervising the employees engaged in that conduct. The extent of the fines and sentences are controlled under our federal sentencing guidelines. Companies, through compliance and ethics programs, can minimize their sentences under these guidelines. So let's take a look at some of our textbook questions listed on pages 994 through 98, specifically questions 1, 3, 6, and 15. And as you review these questions, start to analyze them by applying the concepts we've discussed and what the most likely outcome result. Hopefully you've paused this audio for a moment and looked at all those questions before you actually listen to the answers. So for number 1, you should have found that the defense you would want to raise is the business judgment rule because the board was acting in an informed manner and in good faith. For number 3, Dunaway had a conflict of interest and may have breached a corporate opportunity by not disclosing the matters relating to Eckert. Dunaway had a duty to the stores as opposed to himself or Eckert. Number 6, hopefully you found that Swinia breached his fiduciary duties owed to ERI, the corporation, and to Snodgrass by fraudulently inducing the buyout agreement contracts. Here, the court actually approved exemplary damages of $1 million. And finally, for 15, Gertler was the president of the corporation, and as its president, he owed it a fiduciary duty. He violated that duty when he encouraged the plant manager to leave, sold products at a reduced rate to his son, obtained a loan, and so forth. He did not act in good faith and thus cannot use the business judgment rule as a shield. He violated his ethical categories of loyalty, integrity, conflict of interest, fairness, and doing no harm. We've now just covered chapters 45 and 47 for the day. Let me know if you have any questions.
Good luck with today's lesson.